Hey everyone, welcome back to the deep dive.
Yeah, welcome back.
Today we are going to be diving into something that I think is so important for anyone who's either receiving mental health services or really just interested in healthcare and privacy in general.
Hmm.
And that is iPay, and specifically focusing on Title II, which can sound a little intimidating at first, but
Yeah, administrative simplification. That's a mouthful.
it's a mouthful, and we're going to simplify it for you.
Exactly.
Break it
Is that
down
the goal?
so that you can really understand what this means for you, what your rights are, and what obligations psychologists have when it comes to handling your information.
Yeah, and also how those federal rules, play with state laws, because it's not always so simple, right?
Right.
And then we have some ethical guidelines thrown into the mix as well.
Exactly. We've got sources that range from like the very specific legal language of Title II to kind of the broader ethical codes that psychologists are supposed to be operating under.
Yeah, and what's interesting to me is how those ethical codes sometimes can actually be stricter than the law,
Yeah.
and how psychologists have to kind of balance those two things.
Yeah, it's like this fascinating interplay between, like, okay, what does the law say? And then what does my professional code as a psychologist say? And which one do I follow when there's a conflict?
Yeah, and there can be conflict.
Right, and that's what we're going to be unpacking today so you can really understand how this all works.
Exactly, and hopefully find it, a little bit more clear and even empowering.
Yes, exactly, because when you understand your rights, you're in a much better position to advocate for yourself.
Absolutely.
So let's just start with this basic idea that, okay, psychologists, they've got this ethical code they have to follow, but they also have legal obligations under HIPAA. So generally, are those two things kind of pointing in the same direction?
I would say generally yes, for the most part.
Okay.
Ethical principles and the legal requirements, they're all based on, kind of similar values, respecting people, their well-being.
Right.
But you know what our sources make it clear is that there are times when the two can feel like they're at odds.
Yeah.
And those situations can be really tricky for the psychologist trying to navigate them.
So let's say there's a situation where a law says one thing, but a psychologist's ethical code is kind of suggesting they should do something different.
Mm-hmm.
What do they actually do in that situation?
Well, the sources we looked at really emphasize a few steps, like a process that they should go through.
Okay.
And the first thing is, really understanding what's going on in the situation.
Yeah.
What does the law say?
Right.
What are their ethical obligations?
In that specific context.
Exactly.
Yeah.
And then they have to make it clear that they're committed to following the ethics code.
Okay.
This isn't just lip service. It's about their actions have to be grounded in their professional values.
All right.
And then they have to actively try to find a resolution that, fits with their ethical principle.
Actively that sounds key.
Yeah.
What would that actually look like?
It could look like a lot of things. It could be, consulting with an attorney, getting legal advice, or talking to, an ethics expert through their professional organizations.
Right.
Maybe even trying to discuss the situation with whoever's the relevant authorities to see if there's some kind of alternative way to meet both the legal and ethical requirements.
Yeah.
But importantly, they would also be documenting the whole decision-making process.
Yeah.
Oh,
that's interesting.
Yeah, explaining why they chose to do what they did.
Yeah.
How they arrived at that decision.
That makes sense.
Yeah.
Now, there's this really important point that I think we need to highlight, and it kind of struck me as almost like a line in the sand, and that is that the ethics code can never be used to justify violating someone's basic human rights.
Oh, absolutely.
Like, that felt so important.
It's huge. Yeah, that's a fundamental principle.
Right.
No matter what the law might say, or even what some ethical dilemma might seem to be pushing them towards, a psychologist
Yeah.
cannot use the ethics code to violate your basic human rights.
Yeah.
It's non-negotiable.
Yeah. And then on the other hand, the ethics code can sometimes set a higher standard than the law.
Yes.
So what does that mean for how a psychologist actually operates?
Well, it means if the law allows something, but the ethics code says, we need to do even more to protect this person, then the psychologist has to follow the ethics code.
Okay.
So even if it's legally permissible, if the ethics code says we need to hold ourselves to a higher standard, that's what they have to do.
It's like an extra layer of protection.
Exactly. Yeah. Think of it like that.
Okay. So that's kind of the ethical side of things. And now let's get into the nitty-gritty of HIPAA Title II, this whole administrative simplification thing.
Yeah.
And the main point here was to make the healthcare system just function more smoothly. right?
Yes, exactly. HIPAA was passed in 1996,
Okay.
and it's got several different parts, but
Yeah.
Title II, that's the one we're really focusing on.
Yeah.
And the goal of administrative simplification was to make the healthcare system work better.
Mm.
And that's by creating these national standards for how healthcare information is used and disclosed electronically.
And we're talking about electronic information here because so much of healthcare now is done electronically.
Pretty much everything is moving in that direction.
Right.
It's the way of the future.
Exactly. So Title II has three main components that are
Right.
really important for us to understand.
Yes.
The first one is the privacy rule.
Yes. So the privacy rule governs how your protected health information, your PHI,
PHI.
can be used and shared with others.
Okay.
So like who could see it when they can see it, that kind of stuff.
Got it.
The second was the security rule,
Okay.
which sets out safeguards for how to protect that electronic PHI.
So this is all about making sure that the information is kept safe.
Exactly. Secure.
Secure, yeah.
And then the third component is the transactions and code sets rule,
Okay.
which this one, might sound a little bit in the weeds,
Yeah.
but it basically standardizes the formats and codes that are used in electronic healthcare transactions.
Like what kind of transactions?
Things like billing insurance claims, eligibility checks, referrals, all those kinds of things.
So it's about making sure everyone's speaking the same language.
Exactly. Streamlining all that back-end stuff.
Okay, that makes sense.
Yeah.
Now, this next part is really important for understanding how HIPAA works in the real world. And that's the relationship between HIPAA and state laws.
Yeah. This is where it can get a little tricky.
Right, because it's not always as simple as the federal law trumps everything.
Right, exactly.
So how do we figure out which law actually applies in a given situation?
Okay, so that's where this concept of preemption comes in.
Okay.
We have to look at what HIPAA says.
Mm-hmm.
We have to look at what the state law says
Yeah.
and see which one takes precedence.
And the general idea is that a state law is only going to override HIPAA if it's considered more stringent, right?
Right.
And stringent means what?
Stringent basically means it's giving you more protection for your privacy, or it's giving you more rights to access and control your own health information.
So if the state law is like giving you more rights, more power,
Right.
then that's the one that's going to apply.
Exactly. So it's like, whichever law is stronger for you, that's the one that wins.
Okay. That's a good way to think about it.
Yeah,
And I know you have an example from California law that kind of illustrates how this works in practice.
I do. Yeah. So this is a really good one.
Okay.
Under HIPAA, a provider, let's say a psychologist, has the ability to withhold records from a client's personal representative if they believe releasing those records could cause harm to the client or someone else.
Okay, so that makes sense. Like there are situations where you might not want the information getting out
Right.
because it could actually be detrimental.
Exactly. But here's the thing. California law, it has a stricter standard.
Okay.
It says you can't just withhold records from a patient's personal representative
Hmm.
simply because the provider thinks it's not in the patient's best interest.
Okay, so California is really giving more power to the patient and their representative.
Yeah, they're erring on the side of access.
Yeah.
So in that particular instance, California law is stronger,
Okay.
and it would preempt the HIPAA regulation, meaning the psychologists in California would have to provide those records even if they were concerned.
So that's a great example of how state law can actually offer more protection.
Yeah, it can be really important to know what your state laws say.
Yes, definitely. So let's talk about the listener now. You, the person who's receiving mental health services.
Yeah.
What rights do you have under HIPAA?
We have a number of really important rights when it comes to your PHI, and I think one of the most fundamental ones is the right to access your PHI.
Okay.
So you have the right to see and get copies of your health information that your provider has.
That seems pretty basic. Like, shouldn't I be able to see my own information?
You would think right, but there are some exceptions.
Okay, what are some of those exceptions?
So, for example, if the information was created for a legal proceeding, like if there's a court case and your psychologist was asked to do an evaluation, you might not have access to those records.
Interesting.
Or if you are in a correctional institution.
Okay.
There are situations where access to those records could be denied if they think it would pose a risk to your safety or the safety of the staff or other inmates.
Yeah, that makes sense.
Also, if you're part of a research study
Okay.
and, as part of that agreement, you agreed to not have access to the information while the study is going on,
Right.
That would be another exception.
Makes sense.
And finally, if the information was given to your psychologist by someone else
Okay.
under a promise of confidentiality,
Okay.
then you might not have the right to see that specific information.
So it's really specific.
Yes, it's not a blanket, right, in every situation.
Right.
There are some nuances there.
Okay, now I've heard that there's a distinction between the general notes that a therapist keeps and then like more personal notes.
Yes, this is a really important distinction.
Yeah. Can you explain that?
Yeah, so an HIPAA allows for two types of records.
Okay.
One is what we call the general record, and this is meant to be a comprehensive overview of your treatment.
Oh.
So it would include things like your medication information when your session started and ended, the type of therapy you're receiving, how often you're going, any results of any tests,
Okay.
your diagnosis, how you're functioning, your treatment plan, what your symptoms are, any progress you're making.
So it's a lot of information.
It is. It's a lot of information.
But it's all pretty essential for your care.
Right. It's the stuff that's needed for your ongoing care, but also for things like billing and insurance purposes.
Okay, that makes sense.
Yeah.
And then the other type of notes, those are the
Those are called psychotherapy notes.
psychotherapy notes.
Yeah, these are more detailed notes that a therapist might take during or after a therapy session.
Okay.
They might include their own personal reflections.
Interesting.
You know, their analysis of what you're talking about or specific details that you shared in therapy. And what's important about these notes is they're really for the therapist's own use.
Okay.
They're not considered part of the official record
Got it.
that's needed for treatment or payment or healthcare operation.
How does that difference between those two types of notes affect my ability to actually see them?
That's where things get interesting.
Yeah.
So under HIPAA, you generally do not have a right to access your psychotherapy notes.
Okay.
The reasoning there is that they want to protect the therapist's thought process
Yeah,
and encourage them to be as candid as possible in those notes.
it makes sense.
But, and this is but especially for our listeners in California, remember how we talked about preemption?
Right.
California law actually gives you more access.
Okay.
So in California, if you request to see your psychotherapy notes, your psychologist might be required to give you a copy or a summary.
Wow.
There is one exception, though.
Okay, what's that?
They can refuse to provide them if they believe there's a substantial risk of significant adverse or detrimental consequences to you if you were to see them.
Okay, so it's not absolute, but it's still a much stronger right than you have under federal law.
Exactly.
So California residents, you've got a little bit more power there.
Yeah, definitely.
Okay. Another right that you have is the ability to ask for changes to your information
Yes.
if you think something is incorrect. So like, let's say you see something in your record and you're like, hey, that's not right. What happens then?
You have the right to request an amendment
Okay.
or a correction to your PHI if you believe it's inaccurate or incomplete.
Okay.
However, there are some specific reasons why a provider might deny your request.
Like, what are those reasons?
So they can deny your request if they weren't the one who created the information in the first place.
Okay.
Unless the original creator is unavailable. They can also deny it if the information isn't part of what's called the designated record set.
What's the designated record set?
So that's basically the set of records that you have the right to see and copy.
Okay.
And then they can also deny your request if they believe that the information is already accurate and complete.
Okay, so what happens if I request a correction and they say, nope, we're not doing it? Is that the end of the story?
No, it's not the end of the story. If your request is denied, they have to give you a written explanation.
Okay.
And they have to do it promptly.
Okay.
And in that explanation, they have to tell you why they denied your request. And they also have to inform you that you have the right to file what's called a statement of disagreement.
Okay, what's a statement of disagreement?
So basically, it's your chance to say, I disagree with your denial.
Okay.
And if you file that statement of disagreement, then it gets included with your original request and the denial anytime that information is disclosed in the future.
Interesting. So it's like my side of the story gets to be attached.
Exactly.
Yeah.
It stays with the record.
Yeah.
And you also have the right to file a complaint with the provider or with the Department of Health and Human Services.
Okay.
So you have options.
Good to know.
Yeah. And what if the provider says, yes, you're right, we need to amend this?
What happens then?
Well, they have to actually make the change.
Okay.
And they have to let you know that they've done it, and they have to make a reasonable effort to tell anyone who got the wrong information before that it's been corrected.
Oh, that's good. So it's not just like, oh, we fixed it in our records and nobody else knows.
Right. They have to try to fix it everywhere.
That's good.
Yeah.
Now, another right you have is to actually know who your information has been shared with.
Yes. This is called an accounting of disclosures.
Accounting of disclosures.
Yeah, and HIPAA gives you the right to request this accounting of certain disclosures of your PHI
Okay.
to third parties that were made in the 6 years prior to your request.
6 years? That's a long time.
It is, yeah, so you have a pretty long window there.
Okay, so this applies to disclosures over the past 6 years, but are all disclosures included in this?
It doesn't apply to the normal uses of your information for treatment,
Okay.
payment, or healthcare operations.
Right. So, like, if my insurance company needs to see my records to process a claim.
Exactly, that wouldn't be included. That's not going to show up.
But it does apply to disclosures to things like public health agencies, government oversight bodies, researchers, that kind of thing.
So if a research group was doing a study and they needed some data, that would be something that I could potentially see.
Potentially, yes.
Okay, so let's talk about when you need to give permission for your information to be shared, and that's the idea of authorization.
Yeah, so this is about when you actually have to say, yes, you can share this.
Right, so it's not just a free-for-all. My psychologist can't just share my information with whoever they want.
Not usually.
Oh.
No. In most cases, they're required to get a signed written authorization from you
Okay.
before they can disclose your PHI to someone else for any reason other than treatment payment or healthcare operations.
Okay, those are the big three.
Yeah, those are the exceptions.
Right.
And they also need your authorization generally to release your psychotherapy notes to anyone.
Okay, so what needs to be in this authorization form?
So the authorization has to be very specific. It has to say exactly what information will be shared
Okay.
and any limits on that information, who is allowed to share it and who is allowed to receive it.
Okay.
What they can do with it, it has to have an expiration date.
Yeah.
And it has to tell you that you have the right to get a copy of it and to revoke it.
Okay, so you can always change your mind.
You can, yeah.
Okay. Are there any situations where they wouldn't need my authorization to share my information?
There are a few exceptions that are outlined in the privacy rule.
Okay.
So one is de-identified information.
What's that?
So that's basically information that's been stripped of any details that could identify you.
Okay.
So it's completely anonymous.
Got it.
There are also certain situations where a limited data set can be shared for research purposes without your authorization,
Okay.
as long as there's a data use agreement in place.
And a limited data set is...
It's basically a set of information that has some identifiers removed, but not all.
Okay.
So it's not fully anonymous, but it's more protected than your full record.
Got it.
And then another important exception is if there's a serious and imminent threat to your health or safety or someone else's,
Okay.
then they might not need authorization to disclose your information, even psychotherapy notes.
Yeah, that makes sense. Like if it's an emergency situation.
Exactly.
Okay, now at the very beginning of therapy, when you're first starting to see a new psychologist, you usually get like some paperwork that kind of explains all of this stuff.
Right.
What is that document called?
That's the Notice of Privacy Practices, or the MPP for short.
NPP.
Yeah, and HIPAA requires that they give you this notice at or before your first appointment.
Okay.
And it can be given to you in paper form or electronically if you consent to that.
So what kind of information should I be looking for in this NPP?
Well, it's supposed to be written in plain language that's easy for you to understand.
Okay, but...
And it describes how the provider protects your information. It tells you when your information can be used or shared without your authorization. It outlines all your rights regarding accessing and amending your information,
Right.
revoking authorizations, and getting that accounting of disclosures we talked about.
Yeah.
It tells you how to get access to your health information, who you can contact if you have questions, and how to file a complaint if you think your rights have been violated.
Okay, so it's like your HIPAA guidebook.
Yeah,
Exactly.
exactly.
And they're also supposed to like post it in their office and on their website, right?
Right. They have to have it visible,
Okay.
and they're supposed to try to get you to acknowledge that you've received it.
Makes sense.
Yeah.
Now, we've heard this term minimum necessary standard a lot.
Yeah.
What does that actually mean?
So this means that when a provider needs to disclose your information, they should only share the minimum amount necessary
Okay.
to accomplish the purpose.
So they can't just like hand over my entire file.
Right. They have to be very specific and only share what's absolutely needed.
I like that.
Yeah. It's about protecting your privacy as much as possible.
Okay. Are there any exceptions to this minimum necessary rule?
Yes, there are a few exceptions.
Okay.
So it doesn't apply when the information is being shared with other providers for the purpose of your treatment,
Okay.
or when it's being shared directly with you,
Okay.
or when you've given authorization for a specific disclosure.
Right.
And it also doesn't apply if the disclosure is required by law.
Got it. Okay, now let's talk about these business associates that are mentioned in the HIPAA regulations.
Yeah.
What are those?
So a business associate, or a BA,
BA.
is someone who's not a part of the psychologist's staff,
Okay.
but they receive or use your PHI to provide services to the psychologist.
Oh, okay. Like, what are some examples?
So it could be an answering service that's taking calls
Okay.
and might write down some basic health information,
Right.
a billing company that processes claims, a lawyer who's advising the practice, an accountant, a document shredding service.
So anyone who's kind of working behind the scenes.
Yeah, behind the scenes, but handling your information,
Right.
even indirectly.
So what are the psychologist's responsibilities when it comes to these business associates?
So they have to have a written contract in place with all of their business associates.
Right.
And that contract is a HIPAA contract.
Okay.
And it outlines exactly how the business associate is allowed to use and protect your information.
Mm-hmm.
And the psychologist is also responsible for making sure that the business associate is actually following the rules.
So they can't just like sign the contract and be like, okay, you're on your own.
No, they have to monitor them.
Yeah.
And if they find out that a business associate is violating the contract or mishandling PHI,
Yeah.
they have to take steps to correct it.
And that could involve like terminating the contract?
Yeah. Potentially even reporting the violation to HHS.
Wow. Okay. So it's a pretty big responsibility.
It is, yeah.
Okay, finally, let's touch on those other two key parts of HIPAA Title II.
Yeah.
The security rule and the transaction and code sets rule.
Yeah.
And these are really focused on the technical aspects of how information is handled electronically.
Right. They're all about ePHI, electronic PHI.
Okay, so tell me about the security rule.
So the security rule lays out all these standards for protecting electronic PHI.
Okay.
And they're divided into three categories:
Okay.
administrative safeguards, physical safeguards, and technical safeguards.
Okay, can you give me some examples of each of those?
Yeah, so administrative safeguards are things like the policies and procedures that the practice has in place.
Okay,
You know, they do a risk assessment. They train their employees on how to handle PHI.
makes sense.
Physical safeguards.
Right.
That's all about the physical security of the computers and the building.
Okay.
So things like access control, who can get into the building,
Yep.
who can get to the computers, workstation security, are the computers locked when people step away,
Right.
that kind of thing.
And then technical safeguards.
Technical safeguards are all about controlling access electronically.
Okay.
So passwords, encryption, audit trails.
Okay, and this security rule technically only applies to people who are handling information electronically.
Right, if you're transmitting it or maintaining it electronically.
Right.
But it's considered best practice to follow these rules, even if you're using paper records,
Okay.
just to be extra safe.
So err on the side of caution.
Exactly.
Okay. And the transaction and code sets rule, what's that all about?
So the goal of that rule is to streamline and standardize the administrative and financial transactions
Okay.
in healthcare.
Mm-hmm.
So it requires everyone to use the same formats, codes, and identifiers
Okay.
when they're doing things like submitting claims,
Right.
checking eligibility, obtaining referrals.
So it's all about making sure everyone's speaking the same language electronically.
Exactly. It's about efficiency.
Okay, so let's wrap up. We've covered a lot of information today. What are the key takeaways that you would want our listeners to really remember?
Okay, so number one, you need to understand your HIPAA rights.
Mm.
You have the right to see your records request amendments, know who your information has been shared with,
Yeah.
all those important things. Number two, remember that psychologists have to follow both the law and their ethical code.
Right, and sometimes the ethical code is stricter.
Yeah, exactly.
Okay.
Number three, pay attention to state preemption, especially if you're in a state like California.
Right, where state laws might be even stronger.
Yeah.
Okay.
And then finally, remember that not all health records are treated the same way.
Mm-hmm.
There's a big difference between the general record and the psychotherapy notes.
Right, and you might not have access to everything.
Exactly.
Okay, well, thank you so much for breaking all of this down. It's been really helpful.
My pleasure. It's important stuff to know.
Absolutely. And for you, the listener, I want you to think about what we've talked about today and think about what aspects of protecting your health information are most important to you as you move forward.
Yeah.
You know, what situations might you encounter in your own life when you're seeking mental health services? And how can you advocate for your rights?
Good question.
Thanks for joining us on this deep dive into HIPAA and ethical considerations in psychology.
See you next time.
See you later.